Hey everybody, Attorney Brian Parker here with another exciting video. This video is going to be, someone said, hey, could you do a video on Troy Capital? So I'm doing a video on Troy Capital. Troy Capital is a debt buyer of car repo deficiency judgments of many things, but this one's on Troy Capital and its representation of a Santander assignment, which is neither. It's just not a representation or an assignment, but we'll get into that. The name of this video is the Deficiency Judgment Collection Lawsuit Defense against a Santander assignment to Troy Capital. All right, so when a creditor or collection law firm repossesses a vehicle due to non-payment, they will advertise it, or at least they're supposed to. They let the debtor know that a sale is coming up and they have to advertise the sale and put the correct and legal information in the sale and invite you as the debtor to come along and witness everything so everything is hunky-dory. All that is hopeful. There's laws protecting you, but that doesn't happen. It's a very shady area of the law. The FDCPA does protect you in any bill collecting, and we'll get into that. This is a collection of a Santander deficiency judgment. Now, most deficiencies, meaning the car is sold and the amount the car was sold for, and it's taken off the actual amount owed, there's a deficiency. But that in the industry, it's called a deficiency judgment, whether there's been a lawsuit or not. In this case, they have a deficiency listed in the lawsuit against my client. Again, I always try to do cases with real clients, real cases, real clients. Keep an eye on the amount in your own, if this deficiency situation occurs to you. By the way, it just so happens we're at the highest amount of delinquencies as far as car loans are concerned right now in our nation. You hear one thing how rosy the economy is, and yet there's millions of people in deficiency in their car loans. So there's a need for this video separate from the nice member saying, hey, how about doing this video? So here I am. This is how to handle repossessions in the form of a debt collection attempt for the deficiency judgment, trying to turn it into a judgment. I've done a couple of videos on this already. Let's put them in the sky. There's the video fighting the repossession deficiency judgment. There's the defense to illegal repossession with a killer answer. There's help before and after the repossession protection. I always go like that, and then I get to, here I go, swish. So there's those videos for you. This video, again, is against specifically Troy Capital. Attached to this, I gotta say this. Please don't forget to like, love, and subscribe. It all helps me get information out to you. And if you go to our membership website, collectionstoppersolutions.com, you'll have a video like this, plus tons of templates, plus my show notes, instructions. And those 3 videos I just showed you are chock full of templates, of answers, of counter affidavits. So it's just a wonderful, wonderful website. This video is going to be on YouTube, but for depth and analysis that help you do the actual documents, go to the Collection Stopper Solutions membership. So let's look at the lawsuit that was against my client. Cindy put it up, Shazam, and that is a Troy Capital lawsuit, and they say right in there, you can see capitalized words, that Santander is the original creditor, and they're claiming my client didn't pay, they took the car, and now there's a deficiency judgment, and that Troy Capital has the right to pursue my client because they were assigned the debt. And they say, hey, look at the assignment. They also point to documents, they see documents attached which show the deficiency amount. So we'll go to the Shazam, we'll go to the explanation of calculation of surplus of deficiency, which fully explains why the client owes $6,631.15, because it always does. Shazam. And there you can see the exact, oh no it isn't. the number is actually more. So they are claiming that my client owes $6,000 with a document that says they owe 9. Hey, great, 3,000 disappeared. But even though it in a sense benefits my client, it doesn't help their lawsuit because it's not proof of what they claim it is. So maybe they've got an assignment. You know the assignment is correct and it shows specifically that my client owes this debt to capital. I just know it's going to be completely sound and right. Here we go. Shazam, the assignment. And there you go. Oh, no, it isn't. It's unsigned. I got a little question mark there. It's unsigned. It's actually called a form of assignment. So legally, contextually, it's a form of assignment. It's not the actual assignment. It's a form of one. Or it's the form of assignment that we used. And it's also, it says it's confidential, but here we are attached to a lawsuit. And they claim there's a third line from the bottom of the first paragraph. You can see a Schedule 1 attached. So let's look at that. It doesn't exist. It's not attached to the lawsuit. And we always look for our words to see how serious the creditor is about providing the proper proof to, in this case, Troy Capital. And if you look in the middle, I've oranged it, without recourse. What does that mean? That means they're saying, here, Troy Capital, you have this. You can't sue us no matter how bad it is. And it isn't signed. Nobody is being charged with owning this debt without a signature, without a date. And as your old friend, master purchase and sale agreement on the first line, you get into trouble with these lawsuits, whatever the lawsuit is, and it's got an assignment or bill of sale, go deep on the master purchase and sale agreement. They do not want you to have that. But it is sold, they say, for value received in accordance with the master purchase and sale agreement. So why don't you have that if you're being sued pursuant to that document? So you ask for that, and you're asking for a settlement. They'll settle the case. So we take a look at the lawsuit. Back to the screen, Cindy. And there's our old friend, the mini Miranda warning, right on the bottom. So what? Well, it's not a collection attempt unless there's a collection communication. So if you've got a collection, communication protection, or what's called a mini Miranda, on whatever thing is coming to the client, first of all, 1692E11 specifically states, don't put the mini Miranda warning on the complaint. When you do that, the debt collector loses their protection, meaning the complaint is not a collection attempt communication, so therefore they don't have to later supply the validation rules and rights that you have. But when they put that on the complaint, it becomes a collection communication. They lose their immunity, and now within 5 business days must supply you with the validation law and requirements and warnings that they won't. So attached to this video, I showed you those videos. One of my videos will say, here's a letter, use it if you get in a bind here. So also, the statement of facts, again, refer to documents that don't exist or don't assign anything and even don't show how much is really owed. So that's your complaint. So you take the complaint, you've ripped it apart, you've looked at the forward flow agreement, you're going to ask her if you get into trouble. You have to produce with that information a counter affidavit. Here's the counter affidavit for this video, Shazam, and you can see exactly what I told you. What to look for, what's missing is detailed in the counter affidavit. Attached to this video, I'll also have that in Word template for you, and also another counter affidavit of a different kind against Ally Bank. Just throwing it in there with the video. So you create your affidavit, and now have your kids put their hands over their ears, because we're now going to do some plunking. That's right. Hope Google doesn't get mad at me for saying that. But you're about to be plunked. You take the counter affidavit and you plunk it into your answer, meaning you've done the work when you've done the counter affidavit, when you've reviewed the lawsuit, then it just drops right into your answer. Here is an answer I used in this case. Cindy, first page of the answer, please. Oh, Shazam. Let me get to my answer. And you can see specifically what I told you about the bill of sale is right in the first page. Denied as to this account stated in breach of contract for lack of proof. I've got the form of assignment. We don't know if it's an actual assignment. We do know it's not signed, so it's not an assignment. I've taken that from my counter affidavit and I've plunked it right into the lawsuit. So again, serious plunking will mean you get to settle this case. So you go to page 2 of the complaint, Cindy, and you start off with your affirmative defenses. You always have to have affirmative defenses. By the way, look at that page 2. You can see I don't just say it, I prove it. I say, see Exhibit 1, see Exhibit 1, see Exhibit 1 and the complaint exhibits. Support what you say, all right? The judge will love that. And you can see my first affirmative defense is a failure to attach sufficient documents. That's exactly what I just said, right? So we keep it real, dog. And then the account stated statute that most states sue you under in a debt collection lawsuit. And I provide, and if you look at page 3 of this, Cindy, Shazam, on the second affirmative defense at the bottom, plaintiffs failed to provide any contract or written document to show that such an agreement existed with defendant and plaintiff or that a debt was assigned to Troy Cap. By the way, they did attach something. It just was so badly copied again and again and again that you can't read it. So it certainly wasn't a contract with a signature. By the way, go to the complaint again. Speaking of signatures, Cindy, complaint in this case, statement of claim, statement of fact. Look at the signature. I circled it for you. That is more plunking going on. Somebody took a signature and plunked it into. So normally it's very liberal about what can be electronically signed, cut and paste. Attorneys are a little different. They're saying when they sign, regardless if it's electronic signature or in their actual signature, I've reviewed the above and it is true. Well, it's not true because 6631.15 is claimed to be owed and the proof that supports that doesn't line up. They say there's an assignment from the predecessor in interest, but you've looked at the assignment, it isn't signed. None of what is supposed to be true is true in this case. So if an attorney signs this, they are saying, I've looked at all the documents and I'm not doing this to harass anybody. The above is true, when clearly it isn't. And that signature, you can actually see the square, it's squared off like somebody took a signature piece and just taped it onto this. So that's some fun things I love to look at with signatures. We just pointed to the affirmative defenses in your answer. It's my answer brought to you as a template attached to this lawsuit at collectionstoppersolutions.com. And again, the third affirmative defense, Cindy, you have that page with the third affirmative defense, has again the form of an assignment saying you lack standard, no valid assignment. And the fourth affirmative defense is lack of proof of ownership of the debt and standing. It's okay to repeat yourself. That's how people remember. And the fifth affirmative defense is saying this thing's in a secure trust. I didn't go hard into that in the affirmative defenses. Oh yeah, I did in the affirmative defenses, but not in the counter affidavit. I want to, if it's a Citi card or American Express, I know where that goes. Santander, I'm not sure if they securitize, so I did not, want to waive my right to go in there, but I didn't want to make too much of an issue of it. So attached to this website, this video will be another answer an affirmative defense, as I said, and a counter affidavit. I've collected all the information that was against my client and attached that to this video. Again, you have to look at the assignment they claim assigns. There's nothing there. If you get in the weeds, go and seek that forward flow agreement. They do not want to give it up. Santander does not want their client, their debt by giving it up. So that's a surefire winner there. I am statutorily bound to say this. Whenever you do one of these lawsuits, whether it's a deficiency judgment or a collection lawsuit, what is my mantra? What is it? What's my mantra? That's right. Use their documents against them. In this case, that assignment is for that the proof of how much is owed is not good either, and there's just nothing there. The lawsuit itself is wrong, weirdly signed, and claims to be a collection attempt, which it should not. So there you go. That's your deficiency judgment collection lawsuit defense against a Santander assignment to Troy Capital that was asked of me to do. But generally, you can use it against any deficiency judgment attempt. Focus on those videos again. See the videos: fighting repossession deficiency judgment, defense to illegal repossession with a killer answer, help before and after a repossession, protections. Also, I got free videos on the membership site. How to look at a bill of sale, there's a PDF. How to write a collection lawsuit defense generally, there's a PDF. How to do a counter affidavit, there's a PDF. I'm looking, I hope it's there when the video is on. And I want to thank you for your attention. Again, we're live streaming, so you get to see my shorts, but in the video it looks pretty good. And I thank you. I hope this is helpful. We'll see you in the movies. Bye now.